Hello, ladies and gentlemen. Emeka Wonye today, Friday, the 27th of May, the Children's Day in Nigeria. And I hope those of you who observe it as a holiday, I hope you're having a wonderful time. This is another opportunity for us to have a little conversation. And today I'm going to explain to you what DPA is about. I know I have done this explanation many times in the past, but each time has its own unique emphasis and its own unique purpose. Today, I am explaining DPA for the benefit of lawyers, Nigerian lawyers all over the world, so they can understand what it is. So I believe I am addressing a sophisticated audience who might have some confusions and doubts and uncertainties about DPA. DPA is not a law firm. We are not a traditional law firm. We are not a law firm in the sense of the Legal Practitioners Act of Nigeria or equivalent law of any other jurisdiction in the world. But DPA is a service deliverer in the justice sector. Justice sector has to do with the broad range of services and needs of people seeking justice and fairness in their society. People who are trying to arrange their affairs in such a manner that they will conform with the laws that exist in their jurisdiction. People who are seeking to achieve efficiency, effectiveness in their lives, in their businesses, in their affairs, in such a way to minimize the costs and risks associated with being on the other side of the law. People who are seeking clarity as to what the law means, as to what is expected of them in their society. People who are seeking fairness and equity, or what you may call fair and just society. All these people fall within the justice sector. Law firms are usually practices and concerns that focus on the practice of law in court of law. Usually all over the world, those people receive special licensing to be able to deliver that special focused practice of appearing before the courts, of seeking to operate within the confines of the Legal Practitioners Act and the applicable rules of ethics or rules of professional conduct in their own domain. But as you know, and as I have known from all over the world, there are so many activities involved in the justice sector that are not exclusive preserve of law firms. You can call them paralegal services. You can call them legal support services. This will include investigative services, deposition firms, witness processing firms. There is a whole wide range of this. In more sophisticated society, you have independent companies that handle things like jury selection, jury advisory, witness investigation, background checks, legal research. Even legal research are done by firms that are not law firms. They may have lawyers in those firms, but are not working as lawyers within the context of Legal Practitioners Act, because they don't want to be in law firms. Many thing you must understand is, or rather, many things that will come to your mind, or something you will realize if you have been in this, if you have thought deeply about the justice sector, is that you will notice that the traditional law firms are highly regulated. They are over-regulated. And because of the level of regulation in that sector, sometimes efficiency and effectiveness is lost. I'll give you an example. I came from a background in the United States of more than 28 years of law practice. In the United States, the rules of regulation or regulating legal practice in the United States vary from state to state. They are stringent. They have implication. Of course, if you ask the bar, they will tell you that the essence of the rule is to achieve efficiency and quality of law practice and protection of the society. Well and good, that is the argument, but we also know that much of the rules are not in the interest of society, the interest of the lawyers. They give them an edge. They exclude other people who are equally intelligent and capable of helping, but who may not have the license to practice. So I will give you an example that I experienced personally in the state of Maryland, United States, and some other states in the United States. It is a requirement that if you decline to represent a client, that is, somebody walks up to you and says, "Lawyer, please represent me," and he talks to you, and within 2 minutes you see that you cannot help this person, that he has no legal right at stake, that he has no meritorious issue that you could take to court, or that he is the party at fault, and you say to him, "No, I will not be able to represent you." It is called declination of representation. You have declined to represent that client. In some jurisdictions in the United States, in addition to telling the client that you can't represent him, you are supposed to also write him a letter, mail it to him, and in that letter you will explain to him that you will not represent him. And in that letter, you will explain to him what alternatives he should consider. But above all, in that letter, you should advise him as to the statute of limitation that is applicable in his type of case. So you have to tell him the dates within which he must bring an action if he wants to do so. Now, if you simply refuse to represent a person in the United States or in these jurisdictions in the United States, and you let it go, you could be liable for professional misconduct because you did not put declination in writing. So this is just an example of some of the absurd or rather difficult regulatory problems that lawyers in America have. So some people decide to operate in the justice sector without subjecting themselves to those rules, those regulatory rules. So they decide not to be law firms. DPA, for this and other concerns, because you see, with that rule that says you must reject a client in writing, it means that each person who brings to you useless cases and you turn down those cases, you will have to spend money saying no. Because of that, the lawyers charge consultation fee. You must pay them to talk to them because they know that if they reject your case, they will lose money. So, because of this, ultimately, the litigating public suffer dearly because of regulations in the industry. So, because of this, many organizations and entities decide not to be a law firm. DPA is not a law firm. DPA has a clear reason why it doesn't want to be a law firm. Yet, it wants to be a big player in the justice sector, and it is a big player in the justice sector. I hope this explanation will help some of you who are lawyers to understand what DPA is about. Thank you.